Today I'm going to talk to you about money laundering and 10 topics associated with money laundering. Which government entities enforce your jurisdiction's money laundering laws? Prosecution of money laundering crimes is the responsibility of the United States Department of Justice. There's a special unit in the Justice Department's Criminal Division, the Money Laundering and Asset Recovery Section, which is responsible for money laundering prosecution and forfeiture actions. The United States Attorney's Office across the United States and its territories may also prosecute the crime of money laundering alone or in conjunction with these special divisions. These special divisions must approve any prosecution of a financial institution by the United States Attorney's Office. As required in the statute, there's a memorandum of understanding among the Secretary of Treasury, the Secretary of Homeland Security, and the Attorney General of the United States, and the Postal Service setting forth investigative responsibilities of the federal law enforcement agencies that have investigative jurisdiction over sections 1956 and 1957 of the federal statutes. Investigative jurisdiction generally relates to the responsibility for the investigation of the underlying specified unlawful activity, or also known as the predicate crime. The various federal agencies frequently work together on cases, sometimes with state and local authorities where jurisdictions overlap. The Federal Bureau of Investigation, the Drug Enforcement Administration, the United States Secret Service, U.S. Immigration and Customs Enforcement, the Internal Revenue Service of the Criminal Division, and the Postal Inspection Service frequently conduct money laundering investigations. The Money Laundering Criminal Statute, Section 1956 of the United States Code, provides that it does not supersede any provisions in federal, state, or other local laws imposing additional criminal or civil penalties. Many states, including New York and California, have parallel money laundering criminal provisions under state law. In practice, there is generally coordination, but investigations and prosecutions can be concurrent. Defendants in money laundering cases. Can both natural and legal persons be prosecuted for money laundering? The answer is yes. Both can be prosecuted for money laundering and the offense of money laundering and the related statutes. So what constitutes money laundering? Generally, it is a crime to engage in virtually any type of financial transaction if a person conducted the transaction with knowledge that the funds were the proceeds of criminal activity, and if the government could prove that the proceeds were derived from a specified unlawful activity. Criminal activity can be a violation of any criminal law, federal, state, local, or foreign. Specified unlawful activities or predicate crimes are statutorily described and include over 200 types of U.S. crimes, from drug trafficking, terrorism, and fraud to crimes traditionally associated with organized crime and certain foreign crimes. Under Section 1956 of the United States Code, the transaction is criminal if it is engaged in with 1. The intent to promote the carrying on of the specified unlawful activity, 2. With the intent to engage in U.S. tax evasion or to file a false tax return, 3. Knowing the transaction is in whole or in part to disguise the nature, location, source, ownership, or control of the proceeds of specified unlawful activity, or 4, with the intent to avoid transaction reporting requirements under federal or state law. Section 1956 also criminalizes the transportation or transmission of funds or monetary instruments, cash or negotiable instruments or security in bearer form, 1, with the intent to promote the carrying out of a specified unlawful activity, or 2, knowing the funds or monetary instruments are the proceeds and of the specified unlawful activity, and the transmission or transportation is designed in whole or in part to conceal or disguise the nature, location, source, ownership, or control of the proceeds of the specified unlawful activity. Under Section 1957 of the U.S. Code, it is a crime to knowingly engage in a financial transaction in property derived from specified unlawful activity through a U.S. bank or other financial institution or a foreign bank in a greater amount than $10,000 US. Financial institution is broadly defined with reference to the Bank Secrecy Act statutory definition of a financial institution. The government does not need to prove that a person conducting the money laundering transaction knew that the proceeds were from a particular form of activity. Knowledge cannot be based on negligence, but can be based on willful blindness or conscience indifference, failure to inquire when faced with red flags for illegal activity. Depending on the facts and circumstances, financial institutions and financial institution employees can be prosecuted for money laundering if they have conducted a transaction with the knowledge that a customer's funds were the proceeds of criminal activity. Since 2002, in all but 2 cases, there have been criminal settlements with banks and other financial institutions related to money laundering. The settlements have been based on alleged violations of the Bank Secrecy Act, not for violations of the criminal money laundering offenses. What are qualifying assets and transactions? Is there any limitation on the types of assets or transactions that can form the basis of a money laundering offense? For extraterritorial jurisdiction to apply under Chapter 1956 of the U.S. Code, the conduct must involve over $10,000. For prosecution under Section 1957, the transaction in criminally derived property must be greater than $10,000. Predicate offenses. Number 5. Generally, what constitutes a predicate offense as specified unlawful activities? Right now, there are currently over 200 types of U.S. crimes, from drug trafficking, terrorism, and fraud to crimes traditionally associated with organized crime. Certain foreign crimes are specified unlawful activities, including drug crimes, murder for hire, arson, foreign public corruption, foreign bank fraud, arms smuggling, human trafficking, and any crime subject to a multilateral extradition treaty with the United States. Tax evasion is not itself a predicate offense, but conducting a transaction with the proceeds of another specified unlawful activity with the intent to evade federal tax or file a false tax return is subject to prosecution. Also, wire fraud is a specified unlawful activity. Wire fraud to promote tax evasion, even to defraud a foreign government of tax revenue, can be money laundering. Evasion of foreign currency controls could theoretically be a predicate as well. Are there codified or common law defenses to charges of money laundering? There are no specific codified defenses. Filing of a report of suspicious activity, often called an SAR, with the government may be consideration in determining whether to charge a financial institution, but is not a statutory defense. The defenses that could be raised generally would be that the person did not have the requisite knowledge that the transaction in question involved the proceeds of illegal activity, or that the acts in question did not otherwise meet the statutory elements for the crime. Resolution and sanctions. Number 7, what is the range of outcomes in criminal money laundering cases? A prosecutor can decline to prosecute or enter a plea or settlement agreement with agreed upon sanctions, including payment of a forfeiture or fine. The maximum penalties are fines of up to $500,000 US, or double the amount of property involved, whichever is greater for each violation. And for individuals, imprisonment of up to 20 years for each violation. State and federal regulatory authorities and self-regulatory organizations may bar or suspend individuals from participation in the industry based upon money laundering conviction, or revoke the license of an institution to do business. If a federally chartered or insured bank is convicted of money laundering, subject to a required regulatory administrative hearing, the bank could lose its charter or federal deposit insurance and be forced to cease operations. Such a review is discretionary if a bank is convicted of the Bank Secrecy Act violation. This authority has not been used to date. So what are the laws related to asset freezing, forfeiture, and disgorgement and victim compensation laws? There is both criminal forfeiture following a conviction for money laundering and civil forfeiture against the assets involved in or traceable to money laundering criminal conduct. If a person has been convicted of money laundering, any property, real or personal, involved in the offense, or any property traceable to the offense, is subject to forfeiture. A civil forfeiture action can be brought against property involved or traceable to the money laundering conduct, even if no one has been convicted of money laundering. What are the statute of limitations or the limitation periods on money laundering prosecutions? The statute of limitations is 5 years. Extraterritorial reach of money laundering laws. What does that mean? Number 10, do the money laundering laws applicable to your jurisdiction have extraterritorial reach? Under Section 1956 of the U.S. Code, there is extraterritorial jurisdiction over money laundering conduct involving monies over $10,000 U.S. by a U.S. citizen anywhere in the world or over a non-U.S. citizen if the conduct occurs at least in part in the United States. In part includes fund transfers to a U.S. bank. Under Section 1957, there is jurisdiction over offenses that take place outside the United States by U.S. persons, being citizens, residents, and legal persons, and by non-U.S. citizens as persons as long as the transaction occurs in whole or in part in the United States. The specified unlawful activities can include certain foreign crimes. If you found this presentation helpful, please like, follow, and share. If you have any questions about this topic or need legal representation, please contact me.